What's up, Ron? It's Guys again, and we're here to discuss the lawyer reacts of Trump's appeal. If you missed all the news, recently Trump was found liable in his defamation and libel claim against E. Jean Carroll. And, this was logical. We knew that this was going to happen, that if he lost, if he was found liable, he was going to appeal. So Trump's lawyers have recently filed for that appeal. And in this video, we're going to talk about what actually happened in the underlying trial court case and what is going to go in the appeal and what are the legal odds of that actually occurring. Ron from Rohde Law, and if you subscribe to this channel, welcome back. You'll see that I still have my 7-day-old stubble. So before we get into it, I want to talk a little bit about the underlying trial. So the facts as they occurred were a few years ago, E. Jean Carroll came out and accused Trump of this unwanted touching, sexual assault, maybe it was a rape, whatever the case. He tweeted back that it was fake news and that, it was completely a lie. And her defense is basically that's defaming her statements and calling her a liar. And so she sued him on this defamation or libel claim that by calling her a liar, her defense is that it actually did happen and truth is that defense. Fast forward to the last couple of years, they've been having this case and it finally went to trial and we got a verdict. So let's take a look at this document, but it's basically, did Mr. Trump rape Miss Carroll? No. Did Mr. Trump sexually abuse Miss Carroll? Yes. Did he forcibly touch her? They didn't answer this one. Was Ms. Carroll injured? Yes. And the damages here were $2 million. Now, if you think about it from the jury's perspective, they're going to pick a number that actually has some meaningful impact to somebody like Mr. Trump, whether he's a billionaire, whether he's a multi-billionaire, or maybe he's just a regular decamillionaire like the rest of us. They wanted to send a message with the damages so that it would, cause them some pain. And I think you see this a lot with the Exxon, Mobil, all the gas companies, Comcast. They get hit with judgments that are big enough to hurt their pocketbook. They don't want to just pick a penalty that Mr. Trump pays and then moves on with his life. So here, did Ms. Carroll prove by a preponderance of the evidence? So let's talk about that a little bit. In civil cases, the standard is very, very low. It's a preponderance of the evidence. It's more likely than not. And for lawyers, we usually talk about 51%. And that's a pretty low standard compared to beyond all reasonable doubt, which is what the standard is for criminal convictions. If you're guilty of a crime, you have to prove beyond a reasonable doubt that this act or intent occurred. So here in this case, in Mr. Trump's case, all they have to prove is preponderance of the evidence. It's a very low standard, and I think it makes sense for civil cases. You're not taking away somebody's liberty. Did she prove that Mr. Trump's statement was false? Yes, it's a very low standard. But this brings me to my second point, which is I think this entire trial is a waste of time. If you are trying to prove something that did or did not happen 28 years ago, it's going to be incredibly difficult. For that reason, you cannot bring claims against Mr. Trump directly for battery because it's way past any statute of limitations. And I get it. There's some crimes that we don't have statute of limitations, murder, rape, those sorts of things. But for this, for the touching, for the sexual advancement, it becomes very, very difficult to prove. People's memories fades. The witnesses who may have been a key defense witness, they've either died or they've moved on. It really kind of grinds my gears that you can't defend these types of cases. And what I think is you should just get rid of these causes of action completely. If somebody wants to sue me for libel and I want a counterclaim, but the underlying proof turns on whether we have to prove something that occurred 30 years ago, I just don't think there should be a cause of action at all. It's just incredibly hard to prove, and it comes down to witness testimony and victim testimony and suspect testimony, which is very suspect, and that's a topic for another video. But this is exactly why these types of cases don't get prosecuted anymore, and you don't get civil suits for something that occurred 25 years ago. Did Ms. Carroll prove by preponderance of the evidence she was injured? Yes. If yes, enter a dollar amount, $1 million. and reputational damage, $1.7 million. Okay. So at the end of the day, he's found liable for all of these things. Trump goes back onto Truth Social and he's tweeting on there. I don't know what you call it. What's really going to happen? I think that the appellate standard to overturn a case like this is actually very, very difficult. The appellate court has to find that the judge either abused its discretion and denied a motion for a new trial. They either said something to the jury that was prejudicial. And absent of those facts, unless there is a clear abuse of power, abuse of discretion by the trial court, it's not going to be overturned. Now, maybe on the amount, maybe the amount was outside the bounds, but that's a separate issue of whether they overturn the actual finding of the jury of liability. They may adjust the award amount, but that doesn't change the liability underlying facts. So Trump appeals, no surprise there, and we're going to see what happens on appeal. So if you like that video, smash the like button, subscribe, tell me why I'm terrible at my job. Otherwise, we'll see you next time.